to examine Dr. Ayene's reasons for withdrawing some of the criminal cases Dr. Ayene mentioned in his press statement. And I find generally that all his explanations are laden with contradictions and inconsistencies and betray the questionable motives for his actions. First is the Republic versus Ato Forson and another case. The first reason assigned by the Attorney General for the discontinuance of the appeal is ethical and professional, since, according to him, he was deeply involved in the conduct of his defense as the defense of Dr. Ato Forson. He could not, according to him, in all good conscience, continue the conduct of the appeal. This explanation is a sham, as the Attorney General's prosecutorial authority under Article 88, Clause 4 of the Constitution is exercised by himself or, and I quote, any other person authorized by him in accordance with any law. Pursuant to this, the Criminal and Other Offences Procedure Act 1960 Act 30 permits attorneys of the Office of Attorney General and other persons, including even private legal practitioners, to whom the Attorney General may delegate his powers through an executive instrument enacted pursuant to Act 30 to prosecute. Thus, the fact that he, Dr. Ayene, found himself in a conflict of interest situation did not imply that the entire appeal had to be abandoned. Dr. Ayene characterizes the prosecution of the ambulance case as a political witch hunt. I wholly disagree. The facts show that vehicles purporting to be ambulances were imported into the country in December 2014 in violation of the contract governing the transaction. In the absence of any request by the Ministry of Health, and at a time that the period for supply of the ambulances and the contract had even lapsed, Dr. Ato Forson, by letters dated 7th and 14th August 2014, instructed the Bank of Ghana and the Controller Accountant General to issue letters of credit, which was the agreed means of payment for the vehicles under the agreement. The letters of credit were consequently established on 18th August 2014. Big C General Trading Limited, the suppliers to the vehicles based in Dubai, whose contract had no parliamentary approval, proceeded to ship the vehicles on receipt of the letters of credit. When the vehicles arrived, they were not of the kind specified in the contract and had serious defects with every material part of the vehicles, which rendered them unfit to be described as ambulances. Indeed, a John Mahama appointed Minister for Health at the time, Dr. Alan Simifia, described the vehicles as ordinary vans, not fit for purpose. The defects were so irremediable that from the time the vehicles started arriving in December 2014 to January 2017, when the SR John Mahama administration left office, they could not be converted into ambulances. To date, they cannot be converted into ambulances, and the John Mahama government is back in power. I am of the honest view that the split 2-1 decision of the Court of Appeal, far from confirming Dr. Ayene's position that the case was flawed, was erroneous, and the Republic's chances of having same set aside by the Supreme Court was very high. If Dr. Ayene was convinced that his position would prevail on appeal, why did he not allow the appeal to run its course for a vindication of his views? What did he or his former client, Dr. Ato Forson, stand to lose by the termination of the appeal by the Supreme Court? Ladies and gentlemen, I observe that the real reason for discontinuance of the appeal by Dr. Ayene was that he did not wish to deepen the woes of Dr. Ato Forson any further.